Before we begin this webinar, we would like to acknowledge the traditional custodians of the land and pay our respects to elders, past and present, and also extend that respect to any Aboriginal or Torres Strait Islander people listening today. And as we start, I'll also just quickly pass you over to my colleague Jessica Sullivan from Legal Aid, who will conduct this poll.
Okay, sure. Thank you, Andrew. So yeah, just quickly, guys, to get an idea of your experience, I've just put a poll up now that you should be able to see, and I'll give you a few moments to answer that. It's just how much experience do you have working in care and protection? So it's pretty much all I do. I've only got a little bit, or I've got absolutely none. So I'll just give you a couple of moments to answer that one. Okay, great. And I'll close that and I'll share the results with you guys so you can have a look. So there you go, guys. We've got 55% of our listeners that have got a little bit of experience, some with it's pretty much all I do, and a few people with none. So that's your audience for today. So there's a wide reach there of lots of different types of people.
Yes.
So I'll pass back over to you, Andrew, and I'll just be here for any tech support.
Okay, thank you. Thank you, Jess. Much appreciated, much appreciated. Just with formal introductions, as I said, my name is Andrew Marriott. I'm a lawyer here at Legal Aid. My background has been care and protection, family, and now crime. And I'm currently working in the Community Legal Education Division of Legal Aid. With us today is a very experienced care and protection solicitor, Katie Kelso. Hello, Katie. I'll ask you to introduce yourself, please.
Hello. My name's Katie Kelso, and I am currently the solicitor in charge of care and protection for Legal Aid New South Wales.
Yeah, thank you. Thank you. Okay. And as I said before, there are some handouts on the control panel, including a PDF copy of the presentation we're using today. So please feel free to download that and follow along. And then finally, for housekeeping, again, not to sound like a lawyer, but there is a disclaimer. Obviously, everyone can appreciate in the time of COVID, there are changes coming very thick and fast. So I must stress that the information today is legal information. It's not legal advice, and it is current as of today's date, being the 8th of July 2020. Of course, if you or your clients need any specific legal advice on your situation, feel free to call Law Access. We'll put up the number shortly after the presentation. And we can confirm on the 16th of April, so a couple of months ago, Law Access actually set up a specific team to deal with COVID-19 in relation to legal issues about that. Okay, so what will we talk about today? Today we'll explain under the current circumstances of COVID, and what the scene looks like moving forward in relation to care and protection court procedures, and also for contact, if there's any issues with your clients having contact during their care and protection proceedings. Okay, that's enough talking from me. We will start, I suppose, with a bit of an overview. So Katie, what is the current state of care and protection proceedings generally?
Well, look, for those of you that answered that you have worked in care and protection for a long time or mostly work in that area, it probably won't be news to you guys that it's an area of constant change, and it's an area of law that's constantly being reformed. We had some very significant reforms that came into effect at the beginning of last year in February 2019, and I think in general terms they were reforms that saw law looking to focus in general terms on how to support families and keep children at home, as opposed to seeing children removed and having to go through court proceedings. So definitely the focus of those legislative changes was upon keeping families together and hopefully meaning less removals of children from families. So in general terms, they were really significant reforms. They changed a lot of the legislation that had been in place for some time. There was a big focus on early intervention work with families, so two of the biggest changes were around prioritised access to services. So the legislation now provides that DCJ or FACS or DOTS, and we'll talk a little bit about what that all means a little bit later, but that they can now allow families to access prioritised services where there are children that they consider to be at significant risk. But also the big shift was about making referrals to what we call alternate dispute resolution, or ADR. So children that were again identified as being at significant risk, making sure that those families were able to engage in an ADR process. It might be more commonly known to you as family group conferences, and the idea of that was to try and resolve issues before they became too serious, but also to make sure that families felt as though they were in charge of the decisions that they were making for their children and their families. Some of the other significant changes were, I guess, a flow-on effect of that was to allow the court to make orders where families and DCJ had consent positions about the care arrangements for children. So there were some changes made about the court being able to make guardianship orders by consent. There were some also significant changes made in relation to restoration. So that's the legal concept about whether children can be returned back home to their parents. One of the big changes was that the test for restoration changed. So prior to those reforms, the test was whether there was a realistic possibility of restoration of the children to the care of the parents. But these reforms saw some additional words and some very important words being inserted into the legislation. And those words were within a reasonable period. And a reasonable period is now defined in the legislation as being a period of 2 years. And it was that change was made because there were some concerns being raised by various stakeholders about the old test being too hard for parents to satisfy. So with the addition of those words within a reasonable period, meaning that parents could continue to show that they were making progress within a 2-year period, whether that was going to result in more children being able to return back to their families. The other significant change in that legislation was around Section 90 applications, and I'm sure some of you will be very familiar with that concept, but for those of you that aren't that familiar, Section 90 relates to a section of the legislation, but it's about what applications can be brought after court proceedings are finished to change final orders. So there were some changes to the considerations that the court has to look at when they're making decisions about whether orders should be changed. And that has a significant impact upon parents in particular that are seeking to change final orders in terms of what the court needs to look at. The court now is much more focused on the stability of the current arrangements for children and what the impact on those children is going to be if changes are made to those arrangements. So some very significant reforms, and that, I guess, is a summary of the current state of play in the care and protection jurisdiction.
And just to clarify, when was the date of these reforms?
It was,
is it a particular date or?
Yeah, it was. I think it was the 1st of February 2019 that they came into effect, or it could have been
fairly recent. Okay.
4th of February 2019.
Mm-hmm. Just for abundant caution, I used to get this question when I was working in care and protection. We've got docs, we have FACS, we have DCJ. Who's who? What's the current terminology at the moment?
Look, I think it's confusing for lawyers in the jurisdiction, so I can only imagine how confusing this must be for parents that are trying to go through the system. Essentially, they're all one and the same. Over the last couple of years, there's been a number of changes to the name, I guess, of who brings the applications for care proceedings. So it was docs, and then it became FACS, and in the middle of last year, it became the Department of Communities and Justice, or DCJ. So really, if anyone's using any of those names, they're all essentially correct. And as a general rule, when I'm talking to clients, if they use a certain word, then I will try and use that to sort of make sure that they understand that we're talking about the same organisation. But DCJ is what you'll hear now, and that's their current name.
So DCJ.
DCJ.
So we'll start with just the basic court procedures and how they've been affected during COVID. So in care and protection, what has changed because of COVID-19?
Well, like I think all courts and tribunals, there's been a significant amount of change in the Children's Court in terms of day-to-day practices and procedures for how they've needed to operate. As obviously the situation in New South Wales became quite serious, the Children's Court had to move very quickly to make changes to ensure that those attending court were as safe as they possibly could be attending court. So it was not only the parents, but the lawyers, but also the magistrates and all of the court staff as well. And so throughout this period, we've sort of seen a number of different changes, and those changes have been made as a result of the changes that have been made by New South Wales Health. So originally things started out with the Children's Court taking steps to try and limit the amount of people that were coming to court. So the court was encouraging people to try and reach consent positions about what needed to happen in matters, and asking that only one solicitor appear in court to avoid the need for 4 or 5 solicitors to come, and also for 4 or 5 parties to come. For those of you that have been working in this space for a little while, or even if you haven't been working in this space for very long, some of these proceedings can have multiple parties. Even just a matter that has the bare minimum can see a lawyer from DCJ, a lawyer for mum, a lawyer for dad, and a lawyer for the child, and then you've got everybody that comes along, so it might be mum and dad, and that's just the bare minimum. Sometimes you will have a grandparent, or you might have 2 lawyers for the children, depending upon their ages. So there can be a large amount of people coming to court, and so the court's first sort of stage of trying to reduce that risk was just to try and minimise the amount of people coming into the courtroom. But as things got more serious, the court obviously needed to sort of ramp up what it was doing to try and keep everybody safe. There's been a number of public notices released by the court at various times, which have outlined what steps the court have taken to try and keep everyone safe. And those are available on the Children's Court website if you're interested in having a look at those. But as things changed, the court, as I said, ramped things up, and what we saw happen is that all of the hearings that had been listed between March and May were vacated, and we also saw the court begin to conduct list days electronically. And when I refer to a list day, most courts will have a list day that happens each week. Sometimes in regional areas they'll be less frequent, but for those of you that are based in Newcastle, for example, or in Sydney, those list days will happen weekly, and those are days where the court sort of checks in on matters and makes further directions to try and progress matters. And for anyone that's been in court on those days, they're incredibly busy days. You can have, on a good day, you might have 20 matters. On a bad day, you might have 40 matters. So you can only imagine the amount of people that will be there, the amount of lawyers, the amount of parents, the amount of support workers that will be in the court at one time. And sensibly, the court decided that those were the examples of things that were going to pose the most risk to people, and they became lists that were managed electronically via some what they call the virtual courtroom meeting spaces, where lawyers were able to participate, as we are right now, in a very similar way. For those of you that aren't aware, I imagine a lot of you will be, legal aid lawyers haven't been appearing physically in court for some time. The decision was made fairly early on in the piece for us to provide services at courts electronically. And so what that meant for us was that we had to think about some of our processes as well, because normally pre-COVID, what we would do is receive copies of new applications when we physically went to court, and we'd sit down with clients at court and we'd talk them through those documents. But once we weren't at court, that obviously became not possible. So we had to work really closely with DCJ and also with the court to come up with some new processes that were going to work for us, for the court, but also most importantly, the clients that we were needing to assist. So for the COVID period, what we agreed to and what has been happening is that all applications, new applications for care orders, have been served electronically upon us. And then we have been provided with the contact details for parents so that we could get in touch with them and talk them through and give them some legal advice and talk them through what was likely to happen at court before the day, and then appear for them in court in a very similar way to what we're doing right now. So that's been obviously a significant change. We've had to work through, I mean, if only it was that simple, we've had to work through all of the different ways that has been a positive thing, but also some of the challenges, particularly for our client base, in terms of how they can engage with us. I mean, a lot of our clients don't have access to phones or technology. Some of them aren't contactable at various times. And so we've had to work through how we're going to continue to provide those services as well. So we've been trying to be creative in making sure that we can have clients maybe attend a DCJ office and use their phone to speak to us. So all of those types of things, making sure we've got up-to-date contact details from DCJ to be able to engage with them. So we've been doing a lot of work in that space. In terms of where we're up to right now, I think the court is now I think we're all on the same page in wanting to try and get back to providing face-to-face services, because providing services to clients over the phone, particularly in care and protection matters, is really, really difficult. So really, we're all trying to work together now to see how we can safely return to court in a face-to-face capacity. So we're soon going to see some announcements from the court about how that's going to happen. The court has been working really hard to prepare for us to come back. I've now been to 2 of the children's court registries in the last week to have a look at what I guess the new post-COVID court world looks like. So what it's going to look like from now onwards is temperature checks, screening questions when you come into court. There's the floor markings that I'm sure we're all becoming very familiar with. There's seats in the waiting rooms that are being blocked off so people can't sit together. There's additional cleaning that's coming in. There's hand sanitizer everywhere. There's also steps being taken within the courtrooms to make sure that social distancing can happen within there. From Legal Aid's perspective, we're installing some sneeze screens so that we can provide face-to-face duty services to clients. And so the next stage of I guess the COVID procedures is going to see Legal Aid returning to provide face-to-face services for clients on those first return dates when children have just been removed, and also in final hearings. And those are the 2 court events that, you know, certainly are the most important for us to be providing face-to-face services, and also for parents to be able to physically appear in court. Those are the most important things. They're the big ticket items.
So as of today, where are we, or where are the courts with final hearings? Are they still in suspended animation, or we're waiting on future dates?
Final hearings have been continuing on a case-by-case basis. The court introduced what we call readiness hearing checks, which basically is checking with the court to see whether a matter is ready to proceed to hearing. And part of that process has been having a look, I guess, at all of the logistics of whether hearings can run electronically or in person. So there are hearings that have been conducted electronically with lawyers appearing as we are now, but it's thinking through the logistics of all of those things. We're a very paper-based system, and just thinking through a really practical example, if you want to give the judge a document, how do you go about doing that when you're here and a judge is somewhere else? There are some matters where it's really important that people are in the same room as each other. There are matters where there are multiple parties and there's clients that need interpreters. And there are some matters where essentially the court has just considered that they needed to wait because of the complexity. So really the court has gone through every single matter that was adjourned previously and sort of looked at it and worked through whether the matter can happen electronically or whether it needs to be delayed to make sure that it can happen in person. So look, each case is being dealt with on a case-by-case basis depending upon exactly what is needed.
Where we are. Okay. Well, moving on from that, how can Legal Aid help my clients during the COVID-19 period?
Well, we can help your clients in exactly the same way as we did prior to COVID. I guess the only change is that we're doing that electronically, which, as we've sort of talked about, is not an ideal way to do things, but it is a way that we can do things. So from our perspective, we're still running all of the advice clinics we were running previously. We're also still providing those duty services that I mentioned in terms of assisting parents and representing children on those first days after children have been removed at court. It's just happening electronically. So we can still, I would like to think, provide exactly the same service to your clients. We're just having to do it electronically. I think it's probably important to mention, Andrew, as well, that legal aid on the 1st of July moved into, I guess, a different phase, in the sense that our offices are now physically open for clients to come in. So if they want to pop in and have a chat to one of our staff in reception, they can do that. And we now also have the capacity to see clients in person, where we have the approval of our managers to do that. And I'm encouraging lawyers at Legal Aid to do that, particularly for care and protection clients, because it can be so difficult to go through what can be huge amounts of documents and quite complex documents over the phone.
Yeah. So it's good that there's a shift in terms of clients having at least the ability to come in and engage with legal aid face to face. But as we jump back to the courts, just the next question. So should my client go to court if they have a care and protection matter at present?
Well, I think it's important to know that the court doesn't expect you to be there right now, but you're certainly not prevented from going. If you want to go to court, you absolutely can go to court. The court can accommodate that, and that has been happening throughout the COVID period. It's more that the court just wants to make sure that, you know, we're not having everybody show up, because then we're going to have problems in terms of social distancing and things like that. If you want to go to court, you absolutely can. You'll be subject to the temperature checks and the screening questions, and you'll have to obviously make sure that you're complying with all of the social distancing that's expected, but you absolutely can. The other option is that you don't have to go to court. Your lawyer can appear in court for you, but it's very important that if you have a lawyer acting for you, that you've spoken to your lawyer before court, so the lawyer knows what you want the court to know about what's been happening and what your instructions to the court are. The other way that we can do it is, if the lawyer is going to appear electronically, is that we can call you on the phone and have you listening in to what's happening in court. So there are a few different ways that we can go about it. Making sure that parents have the ability to participate in court proceedings is incredibly important, and we want to make sure we can facilitate that in the best way that we can.
Okay. Well, just in relation, I just have a question coming through. What's your thoughts on community workers going to court with their clients at present?
Look, I think you can absolutely go with a client to court. What you will see if you do that, and I think this is probably just generally reflective of what's happening in the community, is that there are signs up about how many people can be in rooms and in various spaces. So look, it really kind of depends, I guess, on what's happening at court that day, how many other people are there, in terms of whether you'll be able to go into the courtroom or into an interview room with your client, if that's what is going to happen. You absolutely can, and for some clients, obviously, that's going to be really important to have someone there that's supporting them. But I guess think through that there are still some other options in terms of maybe sitting with your client at another location, you know, or with the lawyer. I mean, I think there are other ways that we can make sure that you can support your clients and stay safe as well. I mean, it depends on the client themselves as well. If they've got health issues or, you know, some kind of reason that they don't want to attend court, then it may be best for them to stay away. And so I think it's good to be in touch with, if the client has a lawyer, speaking with the lawyer about the various options and what we can put in place so that everyone feels as though they can participate in the best way possible.
No, great. Just moving on with court procedures, how can my client contact the court?
So, and this is really relevant, I think, for you guys today. The Children's Court has done a lot of work in terms of their own website and making sure that that's been updated with COVID relevant information. So there is all sorts of information on that court website, frequently asked questions about, you know, exactly what we're sort of covering today. Should I go to court? Can I come to court? What should I do if I don't know whether I should come to court or not? You can contact the court to find out. Well, essentially, they've got a list of all on their website, and my suggestion would be that if you know which registry your client has their matter in, to get in contact with the registry that way, or the lawyer. The lawyer will be able to tell you what's going on and how to contact.
So should my client then instruct their lawyer without going to court?
I think that's a matter for the individual client. It depends on, I mean, a lot of, and this is totally understandable, a lot of clients want to, you know, be in court, or they want to hear what is said in court and participate as much as possible. So if they want to do that, as we sort of talked about, I think there's a variety of different ways that that can be accommodated. But there is the option of just having the lawyer appear, and the lawyer's job is always to communicate back to the client what happened in court. And so that's why you'll see, if you've ever been in court, you'll see lawyers furiously taking down notes or writing on their computer about exactly what happened. And that's so that we can tell our clients exactly what was said. You know, maybe the magistrate said something in particular that's important for your client to know, or maybe the child rep raised a concern or said something that it's important for the client to know as well. So it's our job to make sure that we convey back to the client exactly what's happened. So the other option is that the lawyer can just appear and then have a chat to your client afterwards about exactly what happened, what the directions of the court are, so whether they need to file an affidavit or whether DCJ are going to file something, what the next steps are, when they're next going to be back in court, and all of those important details.
Okay. And again, apologies, you might have covered this, but just to reconfirm, how will my client know if they should go to court in person? Is that a future thing, a future development, or?
Look, I think at the moment, as I said, the court's not expecting anyone to be there in person. There's no expectation that parties be there. Once we start moving into a situation where the court starts doing things face to face, there will be expectations that parents are there, but it's really important that when that starts happening, the court communicates that message formally. So I would say that it's probably the easiest thing to say at this point is that if you need to attend court, you will know. So for example, the court will actually note it down that you need to attend court on the next occasion and tell you. Your lawyer will be telling you, or your lawyer will be telling your client that they need to come to court. But also DCJ, if it's a new matter and your client has just had their children removed, then DCJ will also need to be communicating when the expectation is that they need to physically come to court. There's a variety of ways.
Yeah. Just the second part of our presentation, which is a commonly raised area in this the times of COVID, just in relation to clients having contact during this period. So the first question is, what happens if my client's face-to-face contact has been changed or cancelled because of the pandemic?
I think that this is something that is probably relevant to all parents that currently either have proceedings before the court or have had proceedings. It's probably not news to anyone that's listening in today that DCJ have had to make significant changes to the way that they've been ensuring that parents can have contact during COVID. And obviously that's because of the risk to children and to parents and to everyone involved in that process of COVID-19. Every situation, I think, is being treated differently by DCJ. Every family is different and every family's circumstances are different as well. So I think there's some really helpful information on DCJ's website. They've also got a particular page that's set up just about what's happening during COVID. Essentially what they have sort of said is that in circumstances where there is a plan for children to be returned home to a family, that they will do their best to try and make sure that face-to-face contact can continue. But in circumstances where the plan is not for children to be returned home, and this can be in the context of current proceedings or matters which have been finalised and there is no plan to restore the children, that they'll be looking to try and facilitate contact in other ways. So things like Skype contact, Netflix party, those types of things. They'll be looking to change it to electronic to make sure that parents can obviously continue to have contact while this is all happening. So, I mean, it's really like with all organisations, everybody's trying to following along with the advice of New South Wales Health, and as that advice changes, I think things will continue to change in terms of contact. And look, I think this will be an incredibly difficult and stressful and distressing time for parents that are having this happen. But I think it will only be where it is absolutely necessary that it not be in person.
Mm-hmm. So moving from that then, what can my client do if they are not currently having any contact? And then I'll just move to the first option.
Yeah, sure. So I think there are, I guess, a few different possibilities about what's happening for a client in terms of their contact. It could be that contact is not happening at all, or it could be that DCJ is suggesting that contact needs to change to electronic contact. I think the most important and best piece of advice I can give to clients and support workers working with clients that may be in this situation is to talk to DCJ about exactly what is going on, but more importantly, why it's happening as well. So, I mean, every family's circumstances is different. There's also different situations in terms of different locations with COVID and the risk. So it really depends on exactly what's happening. There could be a multitude of reasons as to why face-to-face contact can't happen. For example, if there was a child living in foster care and someone within that foster care family became sick, it may be that child couldn't then come to face-to-face contact for a period of time. It could be that a parent had pre-existing health conditions that put them at greater risk. It could be that the particular venue that contact is occurring at has shut. There's a multitude of reasons as to why things with contact might have changed or needed to stop. I think it's important that we're asking those questions of DCJ as to why it stopped, whether they're going to change things or whether it's going to stop completely, but also importantly when things might change back, because it could be that it just needs to be a 14-day period, or that the particular centre is opening again on this date. So that's the first thing I would recommend is to find out exactly what is going on from DCJ, and I think that will determine what a client should think about doing next. And so we have an agreement with DCJ. Are there any thoughts on the other option of going to court, or? So there are two other options, I guess, if your client is in this situation, and I think the idea of a mediation is also something that we should talk about. Legal aid provides funding for contact mediations when there's a dispute about what the contact arrangements should be for children between families and DCJ. So if, for example, there was a situation where there weren't any care proceedings on foot and something had changed in relation to contact and a parent wasn't happy about that, there are grants of legal aid available for a contact mediation to be organised and for everyone to get together and talk about exactly what's going on with contact and why. So that's an option. And there's also the option of actually going to court. The court has the power to make an order about contact for children. And the court can make orders about how frequent that should be, the duration of the contact, whether it needs to be supervised, whether it can be unsupervised, and also who should supervise as well. When the court is looking at those applications, their focus is always on what is in the best interests of the child and also the safety, welfare and well-being of a child. And they're going to need to take into account a whole range of different things. So things like the age of the child's wishes, what the contact arrangements have been so far, whether contact has been going well, whether it's not been going well, practical things as well, whether the children are required to travel a significant amount, whether there's current difficulties with children travelling in the current circumstances. A whole raft of things need to be factored in by the court when they're making that decision about contact. And obviously, currently, now the court is going to be very interested in what the risk to the child might be of face-to-face contact if that was what a parent was asking to happen, and whether that was going to be safe for a child.
Just, I suppose, for any extra thoughts or something to add on what's been discussed today, but just generally speaking, it might be applicable during COVID or after COVID. From your opinion, what is some general advice to help clients going through the care and protection system?
I think it's worth mentioning just briefly, Andrew, as well, that some of the advice
Yes.
that some of the information I've just given about contact mediations and about contact applications are relevant whether we're in COVID or not. Those are options that are available. Yeah, there are options that are available to parents when they're unhappy with the contact arrangements, whether we're talking about COVID or not. So contact mediations are available, and also at any point in time, whether there's proceedings or whether there's not proceedings, the court can be asked to make orders about contact. So that's the first thing I would just remind people about. So if you do have clients that are raising some concerns or indicating they're not happy with what the current arrangements are, then the advice remains the same. But I think the most important thing is to try and understand exactly why things are the way that they are. And the best way to do that is to make sure that your client is in contact with their caseworker, and you've got really clear information about exactly why contact is happening in the way that it is happening, or why they might be suggesting that things need to change. And that's your starting point in terms of considering whether you might go off to a contact mediation, or you might think about whether you go to court. So I think that's worth knowing. I think just generally, and this is advice that's relevant, as I said, also whether we're in COVID or whether we're not, about, I guess, advice and some suggestions that you could be giving to your clients is that if you've got questions, if your clients have questions, help them write them all down, so that when you're speaking to the lawyer, if they've got a lawyer, that the lawyer, you've got this list of questions that you can work through, and the lawyer can answer all those questions for you. Keeping a record of what's been happening is really helpful, particularly if your client is doing positive things, doing parenting courses or going to contact and having a great time at contact. Keeping some notes about when they went and sort of how it went and their version of events is really helpful when it gets to the point where they might want to file some evidence about having the children come back into their care, or even increasing their contact. It just means sort of like a bit of a diary, so that they don't have to store it all up here. I think some good advice is that if they don't understand maybe something that was said in court, or even what their lawyer is giving them some advice about, don't be afraid to ask and say I don't understand, because sometimes us lawyers, we speak like lawyers and we forget that these legal concepts aren't well understood by the general public, and there's always ways that we can explain things or draw a diagram or ways that we can do better in terms of making sure our clients understand. So make sure your clients speak up, or you encourage your clients to speak up when they don't understand. It's important for clients to do their best to try and read the documents that have been filed in the proceedings, and this can be a really difficult task because, as I said, these documents can be long. Sometimes they can be giant, even on that first day that you go to court, and there can be so much material for clients to read, and it can be incredibly overwhelming. And if your client's really having trouble with that, then I would recommend that they speak to their lawyer and make an appointment for the lawyer to go through those documents with their clients. As the lawyer that's representing that client, the lawyer has to know what's in those documents, and the lawyer has to know what your client says about that to try and give them the best possible legal advice. And so having an appointment with the lawyer to go through, the lawyer will have already read all the documents and they will know what they need to ask the client. So that can be a good way to go through that process. It's important for clients to be contactable, particularly right now in the lead up to court and also after court. Often it was, that it would be the situation at court that you'd be able to have a chat to your lawyer before and have a chat to your lawyer after. But at the moment, because we're not physically there, it makes it a bit difficult. And with the court encouraging people to try and reach an agreement about what needs to happen at court before the actual day, it's important that lawyers can reach their clients so that they can talk through exactly what's being proposed. So staying in touch with your caseworker as well, because if there are changes being made to contact arrangements, it might be that they're wanting to communicate with a client about things changing back to being face-to-face or away from face-to-face, making sure you've got those lines of communication open with your caseworker and also with your lawyer so you can tell your lawyer what's happening is really, really important. And I think the other general advice is that we have some fantastic resources that we have prepared for parents in particular that are going through the care and protection system, but also they're brochures that we've put together for during proceedings, before proceedings, and after proceedings as well. And we've also developed a COVID-19 specific fact sheet about the issues of contact, because we were aware that obviously that would be a common situation that parents were experiencing during COVID. So I'd encourage you all, if you haven't seen them, to have a look at them and to order some as well from our publications unit. All of our lawyers are very familiar with them. There will be lots of them at legal aid offices and also at court locations, and they're just on the screen. You can see the brochures there. There's a series of them there.
Yes. The brochures are on screen along with all the other links to other material. Just Katie, I've got a question that's come through, which may relate to what issues with contact. A person asks just if a client has a concern that either DCJ or another entity looking after the children is not effectively caring for the children properly. It could be possibly an unsafe situation, could be COVID, could be sick relatives. Again, just with that particular set of facts, what's your advice again in relation to issues with contact?
So I think it would be really important if a client was expressing some concerns to talk to their lawyer about exactly what those concerns were, so that the lawyer could then raise that with the DCJ lawyer. It's really important that they're raised in that way so that DCJ can go off and get some information about exactly what's going on and potentially address those concerns. But it also means that the child representative, if you have current proceedings on foot, becomes aware of that as well. And then really what the next step would really depend on what DCJ's answer was. It may be that it may be that there are some concerns that need to be addressed. They can be raised with the court as well. And it would really just depend on what the issue was. But that's obviously the first port of call, is to raise it directly with DCJ. But also ask them if there are some concerns, that what are they going to do to address those concerns? And as I said, they can be raised with the court. And as someone that's represented a lot of children, I'd want to know about things that potentially were relevant to a child's safety in a placement as well. So I'd be interested to hear about any of those issues as well. So everyone has an interest in hearing about those types of concerns.
Okay, no, thank you. As we come to the end of our presentation, there's a few more slides. Having said that, if there are any further questions anyone would like to ask Katie in relation to care and protection, please send them through now. And I should just correct that the slides are not available as a PDF. It's actually the handouts. I misspoke before. So just again, on screen, you can see where to get help. You've got law access. You've got your local legal aid offices, which are thankfully open at the moment, or reopened, I should say. Your COVID-19 fact sheets, and as Katie mentioned, the Kids in Care publication. And and also there is the Children's Court link directly, which you'll be able to receive updates as to what their current state is. All right, and then just moving forward, just in relation to other webinars that we have coming up, Thursday, the 16th of July, We have Work Development Orders Administration Masterclass. On Tuesday, the 24th of July, we have the Child Support Scheme webinar about the Child Support Scheme. And then on the 22nd of July, we have a further webinar entitled Legal Workers for Interpreters, specifically in the area of criminal law. And then, as again, if there's no further questions, I would again just tie it together saying, well, personally, I thank you to Katie. Thank you for attending today and very, very clear answers. And again, if this presentation finishes and you missed an opportunity to ask a question or you had a further question, please do not hesitate to email the email address on screen, that being cle@legalaidnewsouthwales.gov.au. And again, you can access the COVID fact sheet about today's webinar or any of the other webinars that we have presented during this time. And again, if you need any further legal advice, specific legal advice about your situation, please do not hesitate to call Law Access on 1300 888 and 529. So
Andrew,
again,
can I just mention one more really important thing?
Of course.
I forgot to mention
please,
this before, and it is really important, particularly for those listening today. During COVID, we have made some changes to our means and merit tests for people that are applying for grants of aid for care and protection matters. During COVID, we had the CEO approve an exemption for clients applying for care and protection grants in new matters for the means test. So essentially what that means, prior to COVID, clients needed to meet the means test, meaning that we considered their income and their assets. But at the moment, given what's happening with COVID, all applicants for care and protection matters, for new care and protection matters, are exempt from that means test, which means we don't have to have them complete that very long legal aid application. We don't have to have them send us their Centrelink statements or their bank statements. And the idea of that was that all of this additional paperwork was incredibly challenging for people to fill out at the best of times, and particularly difficult in circumstances where they couldn't speak to lawyers face to face. So we're hoping that that change has meant that some of those processes are a little bit more efficient, and that we're not having clients fall through the gaps because they're unable to complete the paperwork or access those documents.
No, thank you, Kate. It's a very, very responsive and effective change. Well, if there's no further questions, again, I'd really like to thank Katie for her presentation today. Again, please send through any further questions, and if there are no further questions, we'll wrap things up. So thank you, everybody, from all over New South Wales for attending today. Goodbye.